Hi, I'm Courtney Ross. I'm a VA accredited attorney here at Greene Marusak, and I'm joined today by the founding partners of the firm, Daniel Marusak and Jonathan Greene. Today, we're going to talk about effective dates. So I want to start by saying this is a really broad topic, so we are really scratching the surface today, but we're going to hit a lot of important points to keep in mind when assessing effective dates, starting with why are they so important? So John, can you talk a little bit about that?
So the effective date determined by VA, it's important because benefits are paid out monthly. So whatever the effective date is, equates to dollars every single month. So you want the earliest possible effective date you can get, because every month that is assigned or isn't assigned equates to real dollars.
Okay. And from a general point of view, what's usually the rule for how VA chooses to assign effective dates if they grant service connection for a disability?
Yeah, so the general rule is date of claim or date entitlement arose. And date entitlement arose usually refers to the date of a condition manifested. So the situation would be that a veteran filed a claim, doesn't actually have a condition yet. Maybe it's a cancer diagnosis or something like that. The date that they actually get diagnosed would be the date entitlement arose for that condition, because while they have the claim in, they don't have the condition yet. So
okay. And there are other ways that a veteran could potentially get an earlier effective date if if VA assigns the incorrect effective date. What are some other general examples or rules that might apply when looking to see if effective date has been assigned correctly?
So looking not at the date of the actual claim, but looking at the date of what's called an intent to file. As long as the claim is filed within a year of that, the effective date should be made back to the date of the intent to file. Something where the veteran files within a year of their separation from service won't be the date of claim. It'll be brought back to the day after the separation from service. So there's the 1 year look back period for increased rating claims. The condition has worsened, and there's submission of service records after a decision. This is a little bit complicated for purposes of this discussion, but we would call these 3.156C cases, where a claim has been denied and at a subsequent period of time, service records get added that help establish entitlement to the benefit, and then the effective date can be brought back to the original date of claim. So those are just a couple of examples. There's loads more. As you said at the beginning, this is kind of a big topic.
Yeah, exactly. Scratching the surface as to things to consider when an effective date is assigned and how you might be able to push it back further.
I just wanted to add, we're saying the date of claim. It's important to note that it's the date of claim as long as you continuously pursue your case, your appeal by filing an appeal within a year of the last rating decision. So it's not always your first claim. So oftentimes we see veterans that filed a claim back in the 90s or earlier, and they're refiling again, within the last year or two. They get a grant. It's not always going to go back to that first time they made the claim. It's only going to go back with their claim stream, as we call it, back to the most recent claim, because that's when they continuously pursued it from.
Yeah, that's a really important point, which is another reason why it's important to be aware of deadlines and the proper forms that need to be filed when you get a decision if you do want to continue to pursue those issues. So one thing in particular I want to talk about with effective dates is VA's unemployability benefit. Veterans can be awarded a total disability based on individual unemployability, or what we often call TDIU, if they're unable to work because of their service-connected disabilities. And there are some special rules, we'll say, that apply to TDIU and effective dates. Dan, can you talk a little bit about that?
Sure. So there's an important court case called Rice v. Shinseki, which found that when a veteran files for an increased evaluation and evidence of unemployability is raised, it becomes part and parcel of the evaluation. So then the effective date should go back to the date of that underlying increased evaluation claim. And as you could expect, that oftentimes is misapplied by VA and results in wrong effective dates. But it is important for being able to get unemployability back for the entire length of the claim, even if it's raised later during the appeal process.
Yeah, and that's a good transition into another topic to touch on is common errors that we see by VA when they do assign effective dates, especially when it comes to TDIU. That's a good example of that.
Particularly with the filing of the 8940 form, which is evidence of the unemployability or job history, I should say, of the veteran. They often treat that as the date of claim for unemployability and ignore the underlying claim that it's attached to for the evaluation purposes.
Yeah, exactly. We see that all the time in our cases. John, are there other examples of common errors that you see VA make frequently when assigning effective dates?
Sure. I think one of the most common that we see nowadays under the AMA is claims that have been continuously pursued, but VA assigns the effective date from the date of the supplemental claim, even when that supplemental claim form, the 20-995, was filed within a year and in response to another previous denial. VA was still assigned an effective date from the date of the supplemental claim. Usually you have to clean up that effective date issue by filing a 996 form, higher level review to get it cleaned up. We talk to a lot of higher level reviewers that they recognize it immediately. They know it's a common mistake, but I think it's some of the, just the name supplemental claim kind of makes people think that they are filing a fresh claim when really it's an appeal. That's a common one. I think that, some of the ones that we mentioned where there are exceptions like intent to file, failing to recognize that there was an intent to file, filed, and then that there was a 526 form, for example, filed within a year of that intent to file, not bringing it back to the date of that intent to file. Dan had talked about TDIU, how TDIU is less of a claim and more of sort of a component of an increased rating claim. VA does require TDIU claims to the issue of TDIU to have that 8940 form, but really TDIU is part and parcel of increased rating claims. VA will often say you got to get an 8940 in, so you get your 8940 in, and then they'll assign the effective date from the date of that 8940, even though the veteran had been pursuing increased rating claims well before the 8940 was submitted. Those are a few. I mean, another sort of red flag in addition to the supplemental claim effective date is when effective dates are made effective from the date of a CNP exam, a compensation and pension exam. That to us is always a red flag because the veteran didn't magically become worse or get a diagnosis on the day of the compensation and pension examination. So whenever we see something made effective from the date of a CMP, we always look to see if there's a reason to challenge it, and there usually is.
Yeah. So it sounds like there's a lot of frequent mistakes that we see VA make when assigning effective dates. If a veteran gets a rating decision granting disability benefits and they believe the effective date assigned is incorrect for maybe one of the reasons we've talked about or another, what are their options for appealing to VA to get it corrected?
Well, you have three options. You can file a higher level review, which John mentioned is often what we do and find that it's pretty effective. You can file a supplemental claim but you'd have to meet a new and relevant evidence standard there. So that doesn't really work with procedural. This is kind of a procedural issue or procedural error. And then you could also take it to the board and file an appeal at the board to have them make the correction. However, that you're looking at a long wait at the board. So that's why we generally pick the higher level review lane. We would say it's a good time to contact a accredited representative also at that point, whether it's a veteran service officer or a law firm like us. But yeah, it's a good time to get someone else involved to take a look at your case.
Yeah, I think that's a great point. And with higher level review, as John mentioned before, you do have an opportunity to talk to an adjudicator. So you can also explain the effective date errors that were made during that call. So like I said, we are really just scratching the surface of effective date issues here, but hopefully a key takeaway is that it's not uncommon for VA to make errors when effective dates are assigned, and you should take a look at that effective date and see if there is merit to potentially appeal it for an earlier date. If you have questions or would like more information, feel free to reach out to us at Greene Marusak.